Tō katoa, and welcome to this, our first Privacy Live seminar for 2020. It's my very great pleasure to welcome you to this and also to introduce Joëlle. First, I'll just run through a couple of admin aspects. The first is that we will live stream this event using Periscope, and it will also be made available through our Twitter account. We are going to use excuse me, Slido for questions, and there's a code that you can log on to for that. So if you go to www.slido, S-L-I-D-O, and enter JJ2020 to post your questions. And I've also chatted to Joëlle, and I know she's really happy to have questions in person as she goes through her presentation. So please do feel free just to pop up when you've got a question, or otherwise, of course, use the app. The toilets, as people may know, are just directly out the door and down at the end of the corridor, and in the event of an earthquake, the assembly place is outside on the road outside. So Joëlle, yes, we're so delighted to have you here in New Zealand, and Joëlle, as you may or may not know, is actually breaking up her holiday in New Zealand and has kindly agreed to do 2 presentations for us while her holiday continues. She is a legal advisor specialising in privacy for more than 11 years. She previously worked for the Department of Human Rights at the Belgian Ministry of Justice for 6 years. She then had the opportunity to support the Luxembourg presidency during negotiations on the GDPR as a privacy expert. She worked for the Belgian Data Protection Authority as a legal advisor for several years, and currently she deals with legal issues for the Secretariat of the European Data Protection Board. The EDPB is an independent European body that promotes the consistent application of data protection rules throughout the European Union and cooperation between EU data protection authorities. And today, Joëlle is going to talk to us about the EDPB, its work, and the challenges ahead. Thank you.
Thank you. Good afternoon, everybody. I'm very happy to be here today. And you're a lot, so I'm super, super happy. I wanted to thank one more the OPC for having me and making this possible, because I think it's very important to exchange information between New Zealand and the EU. So I'm very happy that this can happen. What we will do today is, first of all, to speak about the EDPB, so European Data Protection Board. Then we will see what happened, what lesson we can think about after 2 years of implementation of the GDPR, General Data Protection Regulation. You can interrupt me anytime if something is not clear. If I'm using an acronym that you don't know, please raise your hand and we will do it together, right? And finally, we will also see what is the role of the EDPB compared to the one of its members. And I'll explain who are the members of the EDPB. My first question for you will be to know who has ever heard about the GDPR first, so General Data Protection. Wow, thank you very much. That's really great. And then who has ever heard about the EDPB? A little bit less, but yeah, still consequent. Thank you very much. Then here it is. So let's see how the board is composed. I'll start first by that side. So you see that these are our members. So we have 27, SA stands for Supervisory Authority. It's the same as Data Protection Authority, like the OPC, right? Because you know that in Europe, all of the countries has one or several Data Protection Authority. So the members are 27. You know why it's 27, right? Because we were 28 last February, right? So very good. I mean, we'll laugh, but it's sad, right? Okay. We have 27 members. plus 3 EEA stands for European Economic Area. And these 3 countries are Liechtenstein, Norway, and Iceland. And they are part of the board, which makes us 30 members. Then we have the EDPS. Watch out, it's very close to the EDPB, it's not the same. So everybody is mixing up, but it's not. EDPS stands for European Data Protection Supervisor. And this is the kind of data protection authority for the EU institutions. So its mandate is to check the processing of personal data within the EU institutions. And finally, we have the European Commission that is also part of our meetings, but they don't have any voting rights. So they're just there to listen, to intervene if they have something to say, because they have to make sure that what we do in the board is compliant with the EU law, right? So that's why they're there, but they are not voting on anything. So these are the members. So we are 31, right? 30 members as states and DDPS. Then you have the secretariat. That's where I'm working. I'm sure you noticed me on the picture yet, right? Because you cannot miss me with my hair, I think. So here is secretariat. You also have the chair over here. So in the secretariat, what we do is that we provide analytical, administrative, and logistical support to our members. So what does that mean? We organize a lot of meetings for them. We participate in those meetings. We also draft documents like guidelines or opinion from the board on which they will vote on, right? And then you see that you have a chair of the board. This is Andrea Jelinek. She's from Austria. We also have 2 vice chairs. So we have 1 vice chair, deputy chair from the Netherlands, and 1 from Bulgaria. So you see that this is a mix of a lot of countries, which makes lots of different cultures, all together trying to find a compromise when we do work together. What you also have to know is that we all work, we've decided that we all work in English, which means that for some of the countries it's a little bit more difficult, because we had some members, Spain for example, that had only 2 persons speaking English in the whole Data Protection Authority, which it's very difficult for them to participate in all the meetings if they only have 2 persons speaking English, right? They've undertaken the trainings of people to learn English in order to make sure that they can participate in all the meetings of the board. So this is something that is very important, so that you see how everything goes together. So how do we produce documents? Here you see that we have 12 expert working groups. We call them like this. And you see from the title of the subgroup what kind of issue they're dealing with. You see, for example, that if you see technology, they will deal with all the questions that are relating to new technologies or emerging technologies, and they will produce documents that are relating to that specific topic. If you take social media, again, it will be on all the questions that can be issued on everything that concerns social media. Key provisions is the definition of the key terms of the GDPR to explain how we need to interpret them. In that part of the slide, you always have 1 representative of all the members, right? And this is more at the expert level, so legal advisor in each of the data protection authorities. Then we have the EDPB plenaries, once a month. And what happened is that when they finish the paper over here, it goes to the plenary. And in the plenary, you have all the commissioners of each of the data protection authorities that will vote on document. And this is the place where decisions are taken. and usually it's made by formal vote. Okay. So what can we have now as lesson learned for 2 years of application of the GDPR? Well, actually the board has 2 main findings, because we had to give you a little bit more of context, we had to produce a report of the implementation of the GDPR, because the Commission, under the EU Commission, so the European Commission, under the GDPR has to make that kind of report for the application of GDPR. So they're asking all the EU institutions, so like EU Parliament, EU Council, and us, EDPB, to provide our findings. And these are the findings for the European Data Protection Board. So the 2 findings, the 2 main findings, is that there was a big question to know whether we should review the GDPR. And actually the board said no. For us, it's too soon. We only have 2 years of application. It's very difficult, with all the things we have to put in place, to have a real, position on how it goes when we speak about application of GDPR. So at this point in time, the EDPB is not in favor and find it's premature to review the GDPR. And the second findings, and I think it's very important to note that, is that the EDPB is aware of the fact that the implementation of GDPR creates some challenges, especially for very small organizations. We call them SMEs, which is small and medium enterprise. Besides those 2 main findings, the board has identified challenges in the implementation of the GDPR, and more particularly of the cooperation mechanism. Cooperation mechanism, again, is the cooperation amongst all the members of the board. And I'm sure you can imagine why this creates challenges, because I just explained that we are all different countries, 31 members, with all different cultures and understanding. So we need to work together, and this creates some challenges. I think that the board is totally aware that there is still some work to do in order to further enhance the cooperation mechanism. And to be a little bit more specific, the two elements that have a huge impact on the cooperation mechanism and the cooperation among the members is, first of all, and you will notice that it's very interesting, because the first one is not at all related to the GDPR. So this is something very interesting to note. The first one is that there is a patchwork of national procedure when it comes to handling, for example, of a complaint. Duration, hearing of the parties, this is not at all regulated in the GDPR. It is a national law within each of the members that explain how to handle it, with the deadlines, which are different from one member to another, which makes it difficult to cooperate if you cannot share documents. You see what I mean? Also, in the board, we still have one member with a common law. It's Ireland. So this is the first point that is difficult to handle for our members, and the board is aware of that, and we are trying to find a solution. We are, first of all, trying to map what's the difference we can find, and to see how we can solve them. So we are in the process of doing this now. And the second question, the second element, sorry, I'm sure you can imagine why. Working together, having a lot of meetings, a lot of plenary meetings, a lot of documents to work on, necessitate a lot of resources. And of course, the efficiency of the whole system is depending on the resources each of our members have. as I said in my introduction, we'll see now what is the role of the EDPB versus the role of its members. So the main goal of the EDPB is to ensure consistent application of the provision of the GDPR. This is our goal. And how do we do that? We issue guidelines, general guidelines, to explain, for example, you can find all our guidelines on our website, and we explain, for example, what we think means the Article 3 of the GDPR for the scope of application. We also explain each of the rights, how they have to be interpreted, all those kind of things. And it's to ensure a consistent application and consistent interpretation of the provision of the GDPR within the EU. And then the second option we have is to issue, we call them a consistency opinion. As you might know, within the GDPR, some action that can be taken by our member necessitate an opinion first from the board. For example, the DPIA list, so the impact assessment and the processing activities that will necessitate an impact assessment to be made. This list of processing activities need first to get an opinion from the board, from each of its members, to make sure that all the lists that we produced, so the 27 lists, will be consistent. So this is the second avenue that we have to ensure consistency within the board. And then you see that we also have a role giving advice to the European Commission, for example, when it goes to adequacy decision. And we will see that at the end of my presentation. This is very important to me, because even in Europe, it's quite difficult to understand that the board is not a supervisory authority. We don't have enforcement power. Our members have enforcement power. The EDPB as such, no. So we receive a lot, for example, a lot of complaints directly to the board. We cannot handle them because we don't have that power. It's each of our members that needs to handle the complaint, right? So EDPB is not a super authority. What I wanted to go through with you now is how the GDPR will be enforced as a general rule. And we'll see each of the role, the board and our members separately throughout the whole process. I will go through each of these steps in my following slides. So what we'll do now is to say, for the enforcement, the first question you need to answer is the GDPR applicable to me? Right? And if yes, do I have an establishment in the EU? Why is it important? Because we see that if you have one, the one-stop shop mechanism will apply, otherwise no. And we'll see together the consequences of that. Let's take an example. I'm a New Zealand company, and my business is to offer, to sell products to the EU market through my website. What I have is that I have two establishments in the EU. Establishment means established entity, because in English I know it's different, although it's the term that is in the GDPR, it doesn't mean really what it's supposed to mean. So the established entity that I have as New Zealand company are in Belgium and in Germany, let's say that, right? So, is the GDPR applicable to me? actually the scope of application of GDPR is much broader than only Europe. It covers, I mean, obviously Europe, because otherwise why do you have a regulation in the EU if you're not covering it Europe? I mean, it's totally stupid. But, so it covers Europe for sure, and all processing activities that are done in Europe. But we see together that it also has some covering outside of Europe. In what conditions? These ones. So here you say that I'm a company. Remember my example, I'm a New Zealand company. I have a website and I'm selling goods. I'm selling goods to the EU market through my website. Right? So you agree with me that GDPR will be applicable to me? Very good. So when we have a processing activity that covers data subject, DS is data subject, or individuals that are in the EU, the GDPR does not mention citizenship. It mentions individuals that are in the EU. Meaning that if you, New Zealander, you are in the EU, some of the processing could be covered as data subject in the EU. Because no link with any citizenship. It's the mere fact of being in the EU that makes you covered by the GDPR as individual. You are protected. Your data. I mean, you. So that's the first thing. So having a website, collecting data, collecting person data to sell goods to people that live in the EU. I mean, I have data from individuals that are in the EU, right? So that's the first criteria. And then I'm offering goods, so I'm covered. The alternative condition to be covered is that I'm monitoring behavior of individuals that are in the EU. What kind of example this can be is like you are monitoring the preferences of individuals that are in the EU in order to send direct marketing. This is an example of the second possibility to be covered by the GDPR. So you see that GDPR is not only applicable to EU, but can also cover some companies that are outside of the EU, and in this case, New Zealand companies. Do you remember the second question I put? Is to know whether you have an establishment in the EU. And do you remember that in my example, I've put 2 establishments in the EU. I've said that I have one in Belgium and one in Germany, right? Okay, so in the EU, the way our members are assessing the cases for enforcement purposes is to check first whether it's more a national case, we call it local case, or a cross-border case. Watch out, when we say cross-border, doesn't mean outside of the EU. It's not that it means. It means covering several members of the EU. So cross-border is not outside of the EU. It remains inside of the EU, but it covers a lot of members within the EU, right? So national case, it means that the effect of the processing activity only remains in the sphere of one member, or have impact on individual only in one member state. Cross-border means that it has several member states covered, or could have an impact on individual in several member states. So obviously, if you take a big company that is doing processing activities, will always fall on the second case, because you will have several data subject or individual covered within the whole EU. The way they can cooperate, if they have a case and a complaint about the processing of data, is that, and I will give you some figures to give you an idea of what we are doing now after 2 years of application. They can ask for mutual assistance, and we have already 143 cases. They can also ask to work together, to have an inspection together. We call that joint operation between all the members. And this, we don't have any case yet. So they haven't had the opportunity to use that tool. And then we have what I mentioned previously, the one-stop shop mechanism that I will explain in detail just after that. And for these one-stop shop cases, we already had 157 procedures, and we have 86 procedures that are already closed. Which means that the members work together in a cross-border processing, use the one-stop shop mechanism, and find a solution in 86 cases, right? Thing is that the board, and this is how our mission are overlapping, this is the members that are working together, but if they cannot work together, they cannot agree on a solution in a particular case, this will go to the board, and the board has the power to take a binding decision to force its members to go in one or another direction, right? This has never been used. What does that mean? It means that they can work together so far. So the one-stop shop now. This is one of the most impressive tools of the GDPR because it's one of the most important innovation in the GDPR. Remember my example that I mentioned that the fact of having an establishment in the EU will influence the application or not of the one-stop shop mechanism. Actually, the one-stop shop mechanism is to say that my New Zealand company, if there is a problem, I mean, we have a complaint, there is a problem with the processing activity, and the complaint is received within the EU by one of the members. The fact of having establishment within the EU will have a positive impact on the fact that the New Zealand company will only have to talk to one supervisory authority that we call the lead supervisory authority. That's why we call it one-stop shop. The company that is outside of the European Union will have the benefit to talk to only one supervisory authority to resolve the case. That's when you have an establishment in the EU. Because when you don't have an establishment in the EU, but you're covered by the GDPR, so let's imagine that I have my website, I sell goods to EU citizens, and I don't have any establishment in Belgium or Germany. I just do it from New Zealand. Then I cannot have the one-stop shop. You cannot benefit from the one-stop shop if you don't have any establishment in the EU. What does that mean concretely? Is that instead of speaking to one supervisory authority, you will have to talk to all of them separately. I mean, the one that might be concerned by the complaint. And it happens very often that it's the 27th one. Can you imagine that? Can you imagine talking to 27 different authorities that will tell you something different? I mean, because what's the very interesting point of the one-stop shop is that the lead takes the whole responsibility of cooperating with the others. So the solution will be a consensus one. You know, they are the idea of talking to each other is to reach a consensus among all the members. So the draft decision that they will take, they will adopt, will be one for all of them. Which might not be the case if you talk to 27 different ones. So there is an advantage to have an establishment in the EU, that's what I wanted to say. And also the lead supervisory authority will take, in the one-stop shop case, the whole responsibility of the enforcement of that decision. This is what I already explained previously with the local cases. My favorite slide. So this is one-stop shop. So I'll try to go through with you, and I'm sure we'll be very, we'll see that it's quite straightforward. So I'll take again my example of New Zealand company, right? I have a complaint, and I have 2 establishments in the EU. And let's say that my lead establishment, my lead supervisory authority is the Belgian one. So the lead is the one where you have the main establishment in the EU. So the establishment of the established entity that takes decision relating to a particular processing activity. So the Belgian supervisory authority, after a complaint regarding the processing of person data of EU citizen or EU individual by this New Zealand company, will say, you know what, I will draft a decision saying that I just wanted to make a warning to that New Zealand company, right? What does he do? He do afterwards? As I explained, he has to talk to the other that might be concerned. In my case, most probably will be the second one, which is the German one. We call them concerned supervisory authority. In my example, there is only one, but you can believe me that it's very an exception to have only one supervisory authority concerned. You usually have more than that, and a lot more than that. Let's say that the German one says, okay, I'm okay with the warning you wanted to impose to that company. We adopt that measure. And the lead will be in charge of enforcing it, right? So that's a very easy scenario. What happens if the German one has an objection? Then the lead, the Belgian one, might have to think about the objection. It might accept it, draft a new measure based on the objection received, send it again, but most probably as it was taken into account, we can go that way, right? So adopt it. Now the worst case scenario is the last one. The lead supervisory authority will reject the objection made by the German one. Then they go all together in front of the board, because that's the moment where the board can force a certain decision to be taken by its member. It's the binding decision of the board. So actually, this whole part is among the members, and you have the last part in front of the board. So you see all those two? Yes?
Can you give us any insight how it now works with the UK? Because I think a lot of New Zealand companies will have links with the UK who would have previously been able to be a lead SA or a concerned SA, right? So now do they just...
Yeah, so the question is what happened with UK as they might, before Brexit, they were able to act as lead supervisory authority or concerned supervisory authority, right? So, very interesting question, thank you very much. The ICO, which is the supervisory authority of UK, they lost their membership as from the 1st of February within the board. But they still need to apply GDPR for the transition period, right? This means that for the board, when there is a case that concerns UK, they can be invited within the board for that specific case to participate in the discussion without voting right. Right? Is that clear? Brilliant. So remember what I said? No establishment, no one-stop shop. If you have no establishment in the EU, the GDPR is mandatory to appoint a representative in the EU, because the GDPR is applicable to you, but you don't have any establishment, right? You need to appoint a representative in the EU for the New Zealand company. The board has an official position on the fact that the representative within the EU can never be interpreted as an establishment. You see why? So even if you have a representative, which is mandatory under the GDPR, this representative within the EU will never be assimilated as an establishment, so you cannot benefit from the one-stop shop, even with a representative. So you really need an established entity within the EU to benefit from the one-stop shop mechanism. In addition to all of that, which is it's already a lot, we have the transfer, and this is the transfer. This is the moment where we put person data from the EU outside of the EU. So remember, I said to you that cross-border. When we use the word cross-border, it's within the EU, but for several member states of the EU, right? Now, when we talk about transfers, it's outside of the EU. That's the term we use. In the GDPR, the principle is no data from the EU can go outside of the EU. That's the principle. However, the GDPR also foresees some tools to allow the transfer of person data from the EU to outside of the EU. And we see that New Zealand for that is very lucky, because you have an adequacy decision. And an adequacy decision is a decision from the European Commission saying that actually the way you protect your data within New Zealand is equivalent to the one in the EU. And the principle of not having data flowing out of the EU is that there is a fear that they won't be protected the same way as they are in the EU. That's why. And this is why one of the tools is the adequacy decision. The European Commission saying your framework is equivalent to ours. We can share data with you. And that's what New Zealand has. Thing is, decision from New Zealand dates from 2012, GDPR 2018. So you see the problem. The assessment done by the European Commission in 2012 is based on the previous framework within the EU, which means that they need to review their decision to see whether, based on the GDPR now, the framework of the New Zealand is equivalent to now the GDPR. They will do that quite soon. Hopefully there will not be any problem for New Zealand to get the decision again on the adequacy for transferring data from the EU to New Zealand. I just wanted to mention, last point, that Japan, the adequacy decision on Japan from the European Commission is the first one under the GDPR. So this one won't be reviewed because we know already that it is at the same level as the protection offered by the GDPR. And I'm very happy to take your question now. Come on, I was so clear. That's impossible. It's not my mother tongue. Come on.
Joëlle, I've just got a question about the SMEs
Yes.
And you said at the start that that was one of the areas that you found has been difficult and they've struggled with it. Could you talk a little bit more about that, please?
Yes, of course, of course. So the question is about the SME, so the small and medium enterprise, and the challenges that they have implementing GDPR. We've noticed that some of the provision within the GDPR are for them very difficult to implement. First of all, because they don't have a lot of resources, which is, I mean, in terms of money, but also in terms of staff. They also not really know how to interpret it. Some of the provision of the GDPR, so this makes very difficult for them to know how to implement it. What we've done is that a lot of our members created a kind of toolkit for small and medium enterprise to help the companies in their specific countries to understand and to know what they have to do in order to implement GDPR properly. All the members are sharing those tools all together so that each of them can reuse what another has done, so that's very good. We also received from the European Commission the possibility to apply for a fund, which is you have to describe a project for which you need a fund from the European Commission in order to enhance the implementation of GDPR within your country. And a lot of our members already received that funds and create those kind of toolkits for SMEs. So we try to help them a lot. It's also that there is a misunderstanding, I think, within the GDPR, is that, you know, the two very important things in the GDPR is the accountability principle. So you need to be in compliance with the law. But accountability means that you need to be able to prove it, that you are in compliance. That's the accountability. And the second is the risk-based approach. So in the GDPR, you have to understand your processing activities as a company and to know whether and what kind of risk it represents for the individual. When you know that, you know how to implement GDPR. And I think that the problem with the SMEs is that they think they have to implement everything, which is not true. Because they first need to know what are their processing activities, and second of all, to know what kind of risk it represents in order to implement the right provision of the GDPR. Because if you have processing activities that are very low in terms of risk, some of the provisions of GDPR are not applicable. Again, I have to say, to finish, that we had several cases where we noticed that companies were not complying with the previous framework before GDPR. Although the GDPR is quite just an enhancement of the previous one, but it contains already a lot of what was in the previous framework within the EU. Which means that if they were not compliant at that time, of course they're not now. But fines, you know, when you put fines in a framework, I mean, this has a huge impact on people, and they start thinking that maybe I should comply with the text. Yes?
On a similar vein, have you seen any examples yet of acceptance of some of the more industry standards coming out, things like the NIST framework and ISO 27701 as operational proof for compliance?
Yeah, so your question is about operational proof. I'm repeating for people that are watching us now, of the compliance with the GDPR, like the ISO one. Certification, because this is about certification. We have this possibility in the GDPR to issue a certification, which might be, I cannot say that it will be or it won't be the case, the ISO one, is a topic where we still need to work a lot within the board. We are at the very beginning of that topic. We have issued guidelines on how we interpret the word certification and what it can cover. We also issue those guidelines with a kind of methodology on how the members will assess a certification. But I cannot tell you that we are at the point of saying that if you have that kind of certification, we can consider that you are in compliance with GDPR. That is not the point we are now. I'm not telling you that we won't go to that direction, because I don't know. What I know is that this particular topic is very difficult to deal with, because it's a quite new topic for all the members. We don't have a lot of members with experience with certification, that's why. So unfortunately, the question is not yet. The answer is not yet. I think the minister has a question.
Yes, I would like to ask you about, maybe you can see from the perspective of the European Data Protection Board, so all the data protection authorities, about the load of the burden of the GDPR on agencies, because we don't see a lot of fines, a lot of and that those big proceedings or cases have ended yet. And on the other hand, we see that some data protection authorities, like in UK, they are hiring a lot of new people. Are the data protection authorities prepared for the GDPR? Is it too heavy burden? Are there what's happening there inside? Can they do this? Can they enforce?
Very good question, thank you. Yes, actually, as I mentioned, the problem that is linked to the resources dedicated for within each of the supervisory authorities dedicated to the enforcement and application of GDPR at this point needs to be enhanced. First of all, because a lot of our members are saying that they need more resources in order to make sure that they can participate in all the meetings. Because I can tell you that each of the subgroup, they have at least 2 days meetings or 3 days meetings per month. And we have 12 subgroups, plus plenaries. So they need a lot of people to participate in there, to read documents. Don't forget that this is the work they do for the European, for the board, but they also have work in their national day-to-day life. As I mentioned, for the fines, you've seen that, first of all, for the EDPB, the issuing a fine is not the goal per se. What is the goal is to have compliance with the law. And the fine is one of the tools. We have other tools like warning, reprimand, and it's true that we've noticed that when a member is talking to a company or an organization about a breach of GDPR, actually the company or the organization makes the necessary step while they are discussing to be in compliance with the law. So before even issuing a draft decision. Normally, when you issue a draft decision, it should be on the basis of the non-compliance that you noticed at the first day. But some of our members are a little bit puzzled to, for example, issuing a fines. It's an example, huh? Issuing a fines while the company is in compliance now. You see? Because they were not compliant at the moment they noticed the non-compliance, but by the time they discussed with them, they were in compliance. Also, you have to know that the 86 cases that I mentioned, they are not the most impressive fines, but there are some. But these are the fines we don't talk about. I know what kind of fine you wanted to hear about, but you know. There is one member that is the lead supervisory authority for those companies. I'm sure you know who it is, right? This specific country is the only one with the common law, which makes it very difficult for the others to understand how they work, because they are explaining it all the time at plenary meetings because all the members want to understand how they work. And you see the whole process with my slide, with the draft, objection, non-objection, new draft, all of these in the GDPR, unfortunately, has no deadline. Yeah, but that's it. Then you understand why. They are not in breach of anything because they don't have deadlines. You see what I mean? Timmy.
Hi, one quick question. Could you comment on the factors you take into account in deciding whether or not there's an establishment in the EU?
So the question is about the establishment in the EU and whether or not we take into account the fact that there is an establishment in the EU.
The factors that you take into account, how do you decide whether or not there's an establishment in the EU?
How we decide whether or not there is an establishment. We are not deciding it. It's the company that is notifying it to the members of the board. So the only thing we can say is that we received a notification. I will tell you how it goes. First of all, we have a complaint about a company that is outside of the EU. What the member will do, the member that received a complaint, they will first contact the company by letter to ask whether they are covered by the GDPR. That's the first question, because it might not be the case. When the answer is yes, they will ask, do you have establishment in the EU? Then the company will reply. The supervisory authority can check whether it thinks that it's the case. The criteria for having an establishment is to have an establishment that has the power to enforce decision within the perimeter where it is, so within the EU. So if you have only a mere presence in the EU, that you don't have any possibility to enforce any of the decisions the company is taking about, again, we are talking about processing of person data, okay? I'm not talking about marketing decision. We are talking about, do you have the power to enforce any decision taken by a company regarding the processing of person data in the EU? Do you decide yourself what to do with the data you have in the EU? This means you have an establishment. So you need to have at least, some power to enforce something to be considered as an establishment. So the mere presence of, and that's why, remember I said that the representative will never be assimilated to an establishment. Remember that? It's because this person or this company that will represent only the company outside of the EU won't have this power to enforce any decision, you see? So that's why. So you need that criteria to be able to be an established entity.
So we just have a question on Slido. What role does the EDPB have in adequacy decisions? How much influence does it have on the final outcome?
Thank you very much, guys. I forgot to say your hi. So this is in each of the adequacy decisions, the European Commission has to draft its decision and to submit it to member state in the council, but also to get an opinion from the EDPB. So we are issuing an opinion on the draft decision of the European Commission, and usually what happens is that member states in the council are waiting for the opinion of the board before taking a decision to approve the decision of the European Commission or not. So we can say that the impact and the weight of the EDPB opinion is quite high.
Cool. The next question, how does the EU ensure the right to data portability is enforced on companies that are not established entities in the EU but are possessors under the GDPR?
Processors.
It says possessors, but it may be processors.
Processors. So everybody's familiar with the processor notion in the GDPR. Okay, so the processor in your question is outside of the EU. That's what I understood, right? So okay, so you have a processor outside of the EU, and you have the right to data portability. So well, first of all, you know that the relationship between the controller, because this is the counterpart of the processor, the controller is the entity that decides on the means of the processing and the purposes of the processing activity. And then it can take a processor, tell me if it's too EU centric, because it's the term of the GDPR, that's why. So we have a controller, the entity that will choose a processor. It can choose a processor within the EU or outside of the EU. In that case, the question is the processor is outside of the EU. So let's take a New Zealand company that is acting. Processor means acting on behalf. This is very important because the link with data subject right is not that easy, because usually the only one party that can act to ensure data subject rights or individual rights is the controller. Only if the contract, because under GDPR you always need a contract between the controller and the processor. This is mandatory. So you have a contract between those two parties, right? And the GDPR gives you exactly what needs to be in that contract. Data subject right is not covered, meaning that the controller might decide to ask its processor to act on his behalf when he receives a data portability right. So everybody knows what is data portability right? Okay. But it's not really common because it loses the, don't forget that the controller remains accountable for everything that is done on his or her behalf. So it's very important to make sure that you have a very strong processor to make sure that everything you need to be done will be done in a way you decide that it has to be done. So let's say that the processor outside the EU receives that right to portability, and that the controller, I'm sorry, I have to put all those things to make sure that it makes sense. The processor outside the EU receives the right to portability to be exercised by then an EU individual, and the controller has asked the processor to act on his behalf about that. And the question was the enforcement, so it's an additional layer. Great. So we have these all. So let's say that the processor does not act for giving the portability right to the individual that is requesting it. That makes sense. There is a complaint within the EU, right? Do you all follow me? Okay. Then the supervisory authority will assess the situation. Actually, it's quite easy if you have a controller within the EU. So for the enforcement, most probably that the supervisory authority will go to talk to the controller that will be in the EU and to say, look guy, I wanted to see your contract with your processor. Is it compliant with what is in the GDPR? I've noticed that you delegate the answer to the data subject right to your processor. There is here a problem because I have a complaint about the exercise of this. Can you explain me how you do it? And can you show me that you've chosen the best processor you can have? Two solutions. First of all, it's not foreseen in the contract that the processor can act on data subject rights. Then the supervisory authority will say, oh, but then he's acting as a controller. I will requalify this third-party processor as a controller, and then things start being a little bit more complicated because it means you enforce outside of the EU. Remember that all of the supervisory authority have power within their country. I don't think that the OPC will like having the Belgian supervisory authority coming and say, hey guys, I want to enforce my GDPR on your territory. So that's why we will ask the OPC to help us to enforce. And otherwise, they will go to the controller to say, look guys, there is a problem in your contract. I mean, the data subject right has not been correctly implemented. This is in the GDPR one of the parts that is the highest fine, because data subject rights are very, very important. It's the core of data protection, which means that you can go until 4% of the previous year annual turnover as fine. And this will go to the controller.
Thank you.
I think we will draw it to a close at that point, Joëlle, because I'm just conscious that you've been on your feet for an hour, and you've given us incredible value and stepped us through what can be the maze of the GDPR, and so thank you very much.
Thank you.
I have a little bit of New Zealand for you to take back to.
Thank you very much.
Thank you.